have to tell us today. Board members on the call today: Susan Johnson, our president. Karen Hillsman is on. Obviously, Kathy's here. Cindy Schilling. Wanted to thank, and I'm trying to scroll through this screen. It's hard to get through all of them. Billy's on today. Thank you, Billy. But as a reminder, if you can have your microphones muted, I'm going to mute mine here in a minute so that James can speak to us. Little bio that was sent out to everybody. And once I get through that, James, you can go ahead. But James Cannon is an attorney with Cannon Law, LLC. Mr. Cannon maintains a niche collection practice focusing almost exclusively on commercial collections. With over 18 years of legal experience, Mr. Cannon has represented state banks, national banking associations, commercial lenders, and receivers in state and federal courts throughout the state of Ohio. Mr. Cannon also has experience in acting as counsel for private selling officers, as well as appointing private selling officers on behalf of lenders involving the sale of commercial real estate. Mr. Cannon earned his BA degree from Brigham Young University and his JD from the Ohio State University Michael E. Moritz College of Law. James, go ahead, and we'll hold questions for you till the end, and then we'll have you, those that are on the call, the members, we'll have you unmute and ask questions if you have at that time. But James, the floor is yours, and thank you for your time today.
Brian, thank you, and good afternoon, everyone. Happy to be here and discuss a little bit about private selling officers. I think as our discussion will hone in on, due to some upcoming changes that may or may not end up being law in Ohio, there's a possibility of much more private selling officer involvement and auctioneers serving as those than otherwise has been. So what is a private selling officer? When I first started practicing law, there was no such thing. There was something called a master commissioner, which was a kind of an archaic term. That in federal courts, masters are still appointed. Essentially, it was an officer of the court, and some lenders who did not want the sheriff to sell real estate and wanted to have someone with expertise, an auctioneer, do that. So we used a master commissioner, and we had them appointed. Usually that was for commercial real estate. It was not super commonplace to have a master commissioner appointed, but that did happen. Well, when the downturn in the economy came several years ago with the subprime mortgages, et cetera, there was a ton of foreclosures that started popping up throughout the country and in Ohio. And as a result, there's a backlog in processing. So it was taking a while to have a foreclosure go from start to finish for the property to be sold. Lenders were not happy about that because it was eating into their costs, their carrying costs. They weren't getting paid, et cetera. Some counties were slower than others. For example, I think one of the worst ones was Mahoning County. And in Mahoning County, it would take about a year to sell a property after you got a judgment. If you compare that to some other counties, 2 to 3 months. And so that was frustrating. And so because of this frustration, there was an effort by banks and lobbyists and others, attorneys, to make some changes to the foreclosure procedure. And so they all got together and had a proposal that became law. And part of that law was a private selling officer. So what is a private selling officer? The boring statutory definition of it is a resident of the state of Ohio that is licensed as an auctioneer and as either a real estate broker or a real estate salesperson. So if you want to be a PSO and be appointed as a PSO, you need both an auctioneer's license and then either a broker's license or a salesperson's license. Once you have those criteria, you're good to go under the statute. And once the statute was passed, the banks and lenders started to use it. And I've been involved in a number of private selling officer sales. The goal, of course, from the lender's perspective, is to get a higher net result than otherwise with the sheriff. And the reason being is that the sheriff isn't going to entertain calls from buyers. There's not going to be a lot of advertising beyond the newspaper advertisement. So there's not a lot of skin in the game. And so typically when a bank is in a foreclosure situation, there's going to be a deficiency on the property. And so they're trying to maximize the recovery. And the goal is that in maximizing the recovery, a better result for the bank, and et cetera. So with respect to appointment of a private selling officer, the appointment is right now it's conditional. So if you have, as an auctioneer, if you had a lender client that reached out to you and say, hey, I want you to be a PSO on a property, then if you say okay, then the lender's going to contact the lender's attorney and says, I want to appoint so and so as a PSO. But if you do that, that's conditional. So the judge doesn't have to grant it. And you're thinking, well, that doesn't happen, right? Well, unfortunately, it kind of does. In fact, recently I had a situation in a case in Cuyahoga County where the judge denied the request. And the basis for the denial was, I guess the expressed basis was that the sheriff does a good job, but we all know the real basis for the denial is that you're taking out of the sheriff's money that it's getting from the poundage that it receives once a purchaser buys the property. In this case, the property sold for $300,000 eventually, so the sheriff got $4,500 out of the deal for doing nothing, really. So that's just one example. There are other courts. I was talking to a staff member in a sheriff's department the other day in another Ohio county, which will remain unnamed, but essentially she told me that she had seen a private selling officer get approved for 18 months. And unfortunately, there's a bias that some judges in some counties may have. Some of it is the financial incentive. Some of it is that they feel that a PSO sale went bad, and so they don't want to use them, or they feel like, something was shady with it, which is, not the case. But in any event, there is that bias. So it's important, I think, that you ask the attorney that's working for the lender, just have a discussion saying how likely is the shot of getting a PSO? And if there is this bias, what can we do to ensure that to get us over that hump? And I'll go into that a little bit later. So that's where the current status of the law is. However, there is a Senate bill that's been proposed. It was introduced in July 27, 2021, Senate Bill 212. And I think the most, in my view, significant change with the statute is that with respect to default situations, which I'll explain, the appointment of a PSO is not conditional. So you're taking away the judge's discretion, which is beautiful, in determining whether or not a PSO should be appointed. So what is a default situation? Well, I don't know how familiar everyone is with litigation, but when you file a lawsuit and let's say you file it against John Doe, and if John doesn't respond to the lawsuit after he receives a copy, he's served with a copy, then if you're a lender, you can file what's called a motion for default judgment, and you can obtain a judgment by default, which means that no one showed up. And if you look at the foreclosure statistics in Ohio, in 2021, there were 17,371 foreclosures filed in the state of Ohio. And I took a look at the statistics, and I may I'm probably pretty close, but I would say roughly half of those that weren't dismissed or that weren't settled, half of those foreclosures were default judgments. So, if you take that the dismissals out, roughly, let's say 7,000 to 8,000 of the foreclosures that were filed that went to final judgment were default situations. So if you were to go back to the year 2012, there were 84,196 foreclosures filed, which is 4 times or 5 times as much as we are currently. And so if you kind of read the tea leaves with our current economic circumstances, unfortunately, it could very well be that there will be more foreclosures end of 2022 and in 2023, significantly more than there were in 2021. And so if you look at it, that if we were to get to a place where there's 84,000 foreclosures a year that are filed, then there's probably out of that number going to be at least 20 minimum, 20 to 30,000 default judgments in a foreclosure case, which means that there would be 20 to 30,000 PSO sales annually. Because I guarantee you that if I was advising the lender client and we had a default situation, I say we're doing PSO, and we don't have to file a request. We can just move forward. So again, this is what's in the proposed statute. I think it would be awesome if it passes. When I checked last night, Lexis says there's a medium chance of it becoming law, whatever that means. So it's not low, it's not high, but in the middle. But if this law were to come to pass, and there is also an increase in the amount of foreclosures that are being filed, there's a potential for a lot of work for auctioneers serving as private selling officers. So going back to the current statute, procedurally, if the lender obtains a foreclosure judgment, whether it's default or otherwise, after judgment, they file a request with the court to get a private selling officer appointed. Now, it's supposed to happen after you obtain a judgment. I've seen different lenders' attorneys do it at the same time, and I haven't seen any pushback on that, but technically speaking, you're supposed to wait till after you get the judgment. As far as special criteria for the PSO's appointment, what I said before, you have to have your auctioneer's license or the real estate salesperson's or broker's license. So you would just submit copies of those to a lender's attorney that you're working with. Usually you may want to include a copy of an insurance policy, just a certificate, and redact appropriately so they know you're insured. And that's all that's really needed. However, as I kind of alluded to before, there are some practical considerations that you want to think about, particularly if you're in a county where they have a bias against appointing PSOs, or it's going to be hard to get appointed. So usually what I like to do is I like to articulate something in the request that's about the property that makes it unique or special. And particularly in those types of counties, that's something you want to do. So if you say to the lender, hey, I'll do a site visit and so I can get some detail on the property, because the lender, or if it's an institutional lender, or if it's a hard money lender, or a lender not located in the state of Ohio, they may not have the bandwidth to have somebody go take a look at it. And most lenders, in my experience, they appreciate the offer to look at a property that they're thinking about using a PSO on. So if you do that, then you can provide details to the lender or to the lender's attorney, particularly as to why the property would benefit from additional marketing and your expertise as an auctioneer, and how that's going to generate a better result for the bank, and decrease any deficiency that the borrower, that the entity, or the people, that the individuals that are in the property may have. And you may be able to do that in the form of an affidavit as well, with the goal being that you want to get appointed as the PSO. You can also let the court know that you'll be able to provide access to prospective buyers that the sheriff wouldn't necessarily have the time or want to do, and on more than one occasion. So there's definitely, from a marketing standpoint, it's better to have a PSO sell the property than the sheriff, in my view. So let's say you get appointed as PSO, what happens next? Currently, as the law stands right now, the sheriff has to appraise the property, and the PSO advertises the property and sells it. Now, the statute gives the sheriff X number of days to get the appraisal done. I think it may be 21. It really doesn't matter, because the sheriff's going to take as long as they want. And most counties are fairly quick, but if you have a particular county where the sheriff is dragging his or her feet and getting the appraisal to you, there's really no use complaining about it, because you want to have a good relationship with the sheriff's department the next time around. So you have to be nimble as to what you do and do not do to expedite that. But usually, I would say within a month or so, you get the appraisal, and then you as a PSO advertise and sell it. The advertising, you would use whatever specialized advertising you use as an auctioneer that you currently do for other assets. And then also there would be a standard newspaper advertisement that you would prepare that has the property and the address and how the sale is going to be done. And then there's also a notice process, and that's the notice process within the litigation is typically handled by the attorney. And how I do it is usually would get the ad from the auctioneer that's been prepared, review and approve it, and then I would attach that to the notice and file that in the court. As far as the sale goes, the sale can be either on site or online. Before I go there, one more point on the proposed legislation. So as I said before, right now the sheriff appraises the property, the PSO advertises and sells. With the proposed legislation, the sheriff's appraisal is eliminated, and instead the auditor's value is used. So if you think about it, if you're in a default situation where you want to get the appointment, you can just move right away to sell. So that could make the process very, very quick. You get appointed, you can go ahead and start the advertisement right away and then get it sold, in a month and a half, depending upon, dynamics of when you want to have the property sold. So I think that's a great proposed change. Also from a lender's perspective, it takes out the ambiguity as to what the property will appraise for. So the lender can know going in and say, hey, if the property, the auditor values it at 300,000, I know the minimum bid's got to be, 200,000, 2/3 of that. And I think as far as, their internal metrics as to what they're going to recover and not recover, that's helpful. But I think from a PSO's perspective, it's nice. You can have the speed. You don't have to worry about that. So you can you know, have more certainty as to when you want to pinpoint the sale and have more control. And I think that the more control, in my view, that the creditor has over the process, the better. And I think the more flexibility it has, the better. So this is a good proposed change if it passes. With respect to the sale, as I said, the sale can be either on-site or online. If it's online, the sale's got to be open for at least 7 calendar days. The proposed legislation cuts that to 3 days. And it also says that you got to publicly display the current high bid throughout the bidding process if online. If it is an on-site bid, an on-site auction sale, the creditor or a lien holder in the litigation has the opportunity to submit a remote bid. And that essentially means that you would receive, if you were the PSO, you would receive typically from the Lenders Council an email saying, my client wants to bid X. And that has to be delivered by 4:30 on the business day preceding the sale. There's a little bit of a change in the proposed legislation, talking about the sale date is the date when the real estate sale concludes, is when you have to submit that. But I think if you're working with the lender, you would be able to make sure that they give it to you well in advance of 4:30 prior to, if they're going to remote bid, typically a credit bid. The foreclosing party can cancel the sale before it happens. It can cancel it or postpone it. If they postpone the sale, if the judgment creditor wants to postpone the sale, it has to be reset within 6 months of the initial sale date. If the foreclosing property wants to cancel the sale and it's an online sale, you have to post a cancellation announcement until the end of the bidding period. The statute says if it's canceled and it's an on-site auction, you make the announcement on site. I've never had that happen before, but that's something that's part of the statute. Once the auction is concluded, you take the buyer's deposit, unless there's a credit bid, and you put that in your trust account, and then you file the PSO files a report with the court. Typically, in my experience, I've done that for the PSO. Essentially, I asked the auctioneer to provide me all the information they obtained at the sale. So that would be, usually it's a sheet, and you can craft it however you want, but it has the purchaser's information, name, address, phone, email, and deed information as to what entity or individuals that the deed's supposed to be in. I've seen auctioneers use the sheriff's form as far as the purchaser information form that the sheriff uses. And as long as you have what's in that statute, I think it's fine. You also will include in the report the newspaper advertisement, as well as the advertising fees and the commission amount. The statute also requires that the fee for the title insurance company be included, but that's usually in the confirmation entry, so I wouldn't worry about that too much. Once the sale is confirmed, then there's a title company that closes the transaction. The statute says that the PSO hires the title company. In my experience, it's just, it's coordinated. There's nothing formal, no contract. The title insurance company is listed in the confirmation order, and then they're used to close the sale. And then from your perspective, you deliver the deposits to the title company, you sign a closing statement, you sign the deed, and you're done. So that's kind of the process, the PSO process, so to speak. What I want to do now to wrap up is, before I don't bore you to death with statutory details, is I want to give you some, I guess, practical insights from my opinion, looking at it from a PSO. And it primarily relates to your relationship with the lender. So I always recommend that there be a contract between PSO and lender before you move to get appointed. And the contract, in my view, it just needs to be simple. Doesn't need to be something grand. Just needs to be tailored to the sale. It needs to include a couple basic elements. One, your commission, and one, how much your advertising expense is going to be. So a commission amount and then a cap. If you want to do a buyer's premium, you can do that as well. That's up to you. You can if you want to do a buyer's premium and include the advertising in that and have that be the commission or what you receive, that's fine. However you want to do it. When you're looking at the lender, you want to understand who the lender is. Is the lender, Chase Bank, or is the lender some out-of-state bank that's trustee of a trust that has asset-backed mortgages that's selling the property? The reason I bring that up is that those non-traditional lenders typically like the credit bid, whereas a lot of the banks don't necessarily like to have bank-owned properties. And so unless they absolutely have to credit bid, they're probably not. And the reason I mention that is because if you set up one of the things you want to put in the contract is you want to address credit bid situations and what your commission amount would be. And so you want to be sure that you're not kneecapping yourself if you agree to, only take $1,000 for the sale and it's like a $500,000 property. You want to be sure that you're getting the commission commensurate with what you're selling. And in my experience, the lenders understand that, and they understand that you're entitled to a fair commission for your services. So there's no sense in selling yourself short. But just be aware that if you think that this lender is going to want a credit bid, that you want to be sure that you're getting compensated for the sale if they bid it up. And then I've already kind of talked about the bias against private selling officers that exist. So you just want to be aware of that and make sure that you discuss that with the lender's attorney. With that, I think that's all my prepared remarks. So I'd be happy to answer any questions you may have.
James, I'll thank you personally for coming on today and talking. I'm sure there might be some questions. I think that was good clarity. And if we do have questions, just be aware somebody else might try to ask the question at the same time. Zoom calls always get interesting. But take a few minutes if any of the members on or the board members on have questions. Now would be the time for James. I think James, probably you have an additional 10 minutes probably to answer questions. Does that sound about right?
Yeah.
Okay. So anybody at this time have questions for James?
Yeah, I don't mind starting, I guess. So James, you had spoke there several times throughout that about biases towards PSOs. Could you clarify, I guess, a little bit what you mean? Are they biased potentially? You're saying they're painted in a bad light, or what exactly do you mean by that?
Yeah, so I think that it's kind of two-part.
Mm-hmm.
So one of the reasons they're biased is because against it, some counties, is because if a PSO is selling a property versus the sheriff, and the sheriff doesn't receive any income from that. Gotcha. So the example I gave before is, there was a property that the commercial property that sold for $300,000 and the sheriff's cut of that was $4,500. Whereas if a PSO would have sold it, the PSO's commission would have been, whatever it would have been, but the sheriff wouldn't have got the $4,500. And so if every creditor wanted to have a PSO appointed instead of the sheriff, then the sheriff's going to lose revenue. And so,
Gotcha.
so that's one aspect. And then there's a second piece to that, is that some judges, it may be more smaller counties, but they're just biased against folks that are not within their county per se. And some may feel that the PSO process is just a way for banks to harm their constituents, which is not the case. And so, I think that, some judges just would prefer to have the sheriff sell it. And so that's kind of what I'm getting at. Does that make sense?
Gotcha. Yes, thank you.
Sure.
Thank you, Brandon. And if there are other questions, and I didn't ask you, Brandon, but if you do have a question, can you introduce yourself before you ask your question, just so James knows who he's talking to?
Yeah. But just to recap that then, Brandon Arling, I live over here in Mercer County. I am a realtor auctioneer as well. So
Great. Nice
Awesome.
to meet you, Brandon.
Awesome.
nice to
Thank
meet
you.
So I think I got it.
Next. Go ahead, James. What'd you
Um,
say?
I was just going to say, I think Mark put this in the chat. He talked about what happens if the property has not reached the reserve price and does not sell. How is a second auction conducted? And so I'll answer that in two parts, I guess. So I primarily deal with commercial real estate, not residential. And so with respect to residential properties, if the property doesn't sell the first time, then you can put in the advertisement for a second bid date in the initial advertisement for sale. And so that's one way to handle it. And it depends on the property. There is a law in Ohio that says if the property doesn't sell the first time, you can request to lower the minimum bid to X amount. And so in a commercial property context, usually the lender isn't thinking about the second sale until the first sale is done. And so if that first sale concludes and there's no bid, no sale, then in my experience, what typically happens is the lender goes back to the court and requests that the minimum bid be lowered to whatever amount you as an auctioneer feel will get the property sold, because you would have a flavor as to who's been calling, who showed up, etc. And so whatever that amount is would be set, and then you would have the second sale. And it would follow a similar process. You'd have to advertise it, and then provide notice, and then have the sale. Hopefully,
Okay.
Mark, that answered your question.
Thank you, James. Any other questions?
Hi, I'm
I've
Cindy
actually got
Schilling.
go ahead.
I'll mute. You can go ahead, finish yours.
Well, I was going to say I've got about probably 3 other questions, so I can you go ahead, Cindy, and we'll see if you ask the same one as I do.
Okay, I'm Cindy Schilling. I'm in Franklin County, and I am
Hi,
a
Cindy.
PSO. And I've been doing a lot more properties, so I get everything you're saying. I agree that we need to shorten the process. I remember reading this in the Ohio Revised Code that at some point a bank has to offer the property absolute. And I can't remember now, like, is it because it didn't sell? Because, what's the frustrating part for me is you do this work, you market the property, and then the bank comes in, like you said, under the line before 4:30, place this bid. And I understand they're trying to protect assets. And then there's ones that, of course, you can't help reclaiming. reclamation is going to happen. So how do I get them to a point where I can sell it absolute?
Without any minimum bid requirement.
Mhm. Correct.
Yeah. So I don't think that I've ever had a PSO sale where it's been an absolute. I've had discussions around a couple properties doing that, but in my experience, banks are just really loath about doing that. And I think it may not necessarily be because they don't want to get rid of the property. I think one of the concerns may be a regulatory concern,
Mhm.
that you get some joker, maybe that's not the right term, some individual from the the feds, some regulator that comes in and says, I want to look at these files, and then notices that you sold a property for $5,000 or whatever it's sold for, 10 grand. Let's say it's a junk property. And say, well, what was the minimum bid of 0? Well, why'd you do that? You trying to harm this guy? So that may be I don't know, an off the board example, but I think that banks are always very concerned from a regulatory perspective about liability that they may or may not incur. And sometimes the regulators are subjective rather than objective. And so that may be part of why they don't want to sell it at absolute.
Yeah, I know they have to worry about their audits. They don't want to be audited and find this stuff. I'm just trying to find a better way to make it more streamlined for everyone. But it's been such an up and down roller coaster with some of these properties, offering it for a third time.
Yeah, that's kind of ridiculous, right? Have you, in your experience, has the lenders wanted to get approval on a set bid that you say this is what it's going to sell for, or they just have been reselling it at the same price?
Resale at the same price.
Yeah. So I think that may be the issue. Maybe suggesting to them, instead of doing that, saying, hey, I don't want to be selling it a third and fourth time. Let's just do X, and let's agree to that and get the court to approve it, and then move forward. I guess that would be my recommendation.
One more question. Just as of late, I've had a couple properties that are taking forever for me to execute the deed. Various,
Okay.
I don't know what all the problems are, because I'm dealing with a title company and a law firm. But is it pretty normal? I'm thinking, because I've been doing it for a year and a half, and I'm finding out it's pretty normal to expect, 3 months for these to close. Is there any way to speed it up?
Well,
I like to smile.
Yeah. 3 months seems a long time to me. I think if my lender client would be screaming at me, I think if it took 3 months. So you're saying 3 months, so the sale has happened?
Yeah.
And then it takes 3 months. So I see, that it usually takes about a month for the sale to be confirmed. And
Yeah,
then
depending on the county.
Yeah, depending upon the county. But from there, the title company should be able to do what they need to do in a couple weeks, in my opinion. I mean, if it's taken 3 months, to me, it seems that there's something else going on. Because that shouldn't happen.
Okay,
I don't
last
know.
question, so we can get back to Brandon. Thank you so much for your time.
Sure.
So one of the other things I've run into is the title companies don't want to pay us until it records. And one of the title companies I use for my regular sales, I said, why do I get a check at the closing? And now I'm waiting months to get a check for this. And they said they may not have gap insurance.
Yeah. I think you should get paid at closing. So I mean, I guess I would try to use a different title company.
I'm not permitted.
Oh, I don't know. That
Okay.
strikes me as odd.
Okay. You know, being newer, I've been in the business 15 years, but it's always been regular transactions. And this last year and a half doing these PSO sales, it's like, who's, you know, is the dog wagging the tail, or is the tail wagging the dog?
Yeah, I don't see why there would need to be any gap. I mean, the sale's been confirmed. As long as the title company shows that, you know, there are no other lien, there shouldn't be any issue, a lien issue
Okay.
that would make them uncomfortable
Okay.
if it's been done right. Yeah, they should be able to rely on the confirmation entry and that the liens are released, and they should be able to rely on their title work. If their title work is good, they shouldn't be worried, in my
Yeah.
opinion. That's from my
Well-
perspective.
All right. Thank you for your time.
Sure. Nice talking
Thanks.
to you.
Thanks, Cindy. Brandon, I think you said you had a couple other questions potentially.
Yeah, I'll try and wrap these up. 3 questions. The first 2 kind of mesh together here. So the first one, I guess, James, what's the best way in like my county to kind of find what foreclosures out there are available for me to apply to become a PSO? I guess, you know, is it all of them, or at what stage? I guess I'm a little green in that part of the process.
Okay. I guess my initial recommendation would be to, if you have relationships with banks in your county where you know the bank employees, I would get to know them. The other thing you can do is, I'm assuming that Mercer County, like the clerk's office, has a case docket that's publicly available.
Yep.
So you would have to kind of trial and error to figure out which cases are foreclosures and which are not. But maybe, you know, look through and determine which those are, and reach out to the attorney and say,
Okay.
hey, and introduce your, because the attorney should have, if Mercer County has the filings and you can view the actual complaint, then the attorney's email address should be listed on there. So you could, you know, look at the foreclosure complaint and just send him or her an email saying, hey, introducing yourself, and I'm an auctioneer here locally. I see you're foreclosing on this property. I'm interested in serving as a PSO for you, and you know, kind of market that way would be
Okay.
a possibility.
Okay, that pretty much takes care of the next question. Then I was going to try to ask, what's the best way to determine which attorneys in the area are relevant to to these types of foreclosures? But it's predominantly anyone, just whoever's going through said proceeding at that time, correct?
Yeah, I mean, there's some that would be local, and a lot of the foreclosures, at least in Ohio, you know, there's some law firms that are called, you know, foreclosure mills, and who exclusively do foreclosures. And so those are, you know, those 3 or 4 or 5 firms in Ohio, you know, handle probably the lion's share of, you know, residential foreclosures for sure. And so
Gotcha.
so they may, you know, it may be getting to know some of those folks in those law firms
Okay.
as well.
And then lastly, in terms of like ORC, just to help myself understand the process better, what is the proper revised code if I wanted to peruse through that I should just try to familiarize myself with?
Yeah, so it's a little bit disjointed, but I think the main section that you want to take a look at is 2329.152. And Brandon, my email is James at Cannon, CANNON law, Ohio.com.
Okay.
So if you have any other questions, you know, I'm happy to Kathy, it's canonlawohio.com. She put that in the chat. I'm sorry, I didn't.
Oh,
I may not have enunciated that very well.
at canonlawohio.com.
Yeah.
Yeah.
And you can, I'm happy to, if you're wanting more code sections, I can shoot you some more as well.
Okay, sounds great. Thank you.
Thanks,
Yep.
James. Brandon, thank you for your question. Cindy. James, I want to be respectful of your time. I think we passed the 10 minutes, which is good. This is good information, so I appreciate that.
Sure.
I think the email there, Kathy put it in. Did she get it corrected? I can't see the chats on my phone, so I assume she got it corrected. But you can also reach out to me, Brian at auctionohio.com, and I can get you connected with James if you have questions. Of course, someone's calling in as I'm trying to talk.
Okay. I put it in there in the chat. So
Perfect. James, anything else you want to share before I end the session?
no, I don't think so. Just
Okay.
thank you.
Well, members, board members, president, Kathy, thank you all. I don't think there's anything else left.
Thank
We're
you.
available. We're available if you need us, board members. Our contact information is on the website. You can always reach out to us. We plan on doing this again next month, and we'll have more information out to you regarding the next topic. James, again, thank you very, very much for your time. And Kathy, I think we're going to go ahead to end the session. Thank you all.
You're welcome.
Thank you.
Thank you.
Sure.